So, keeping in mind that everything that you do when you're promoting an event, from getting the artist, you want to make sure that you have the right to use that artist's image. Even if you're promoting for your event, you want to get approval. You want to say, hey, this is what we're going to do. You want to get a framework of what rights you have. You want rights to the image that you're going to use to promote the artist. You want to get right to use the artist's name on your flyer. And what this does is you have something in black and white. Right? I'm trying not to do my legal lingo, but you have something in black and white. You have a chain of conversation with the artist, with their management, showing that they were very much involved in the process of getting this event together. Because you have a lot of artists that would skip out. I've dealt with those issues. They don't show up. They're smoked out. They went to the studio. They couldn't wake up. All the stories that you hear, you want to make sure that you have the authority to use the image, logos, that. The other thing that I want to raise is something that's been happening. You have a lot of, in today's market, you have situations where individuals, companies, promoters are using the monikers, the image, the likeness of the deceased artist. Or they're using the phrase or the logos of concerts or big shows that happened in the 90s. Thinking, that was the 90s. They haven't had it in a long time. We're just going to revamp it. We're going to make it 2013. You cannot do that. Okay? Because the estate of the deceased individual will have the right to use that to promote and to have monetary gain. So you have to also keep that in mind when you are promoting your concert. I'll give you an example. I'm dealing with a case right now where a major company, I can't call any names, unfortunately, but my client is a major company, and they have a trademark. They have a trademark on their phrase. Okay? And this other company comes in, and, they're on TV and everything else, and they're having a campaign, promotion campaign. They're, promoting this membership drive that they have. And we're like, wait a minute. That's our client's phrase. The client emails us, we need to do something about this. So now we're sending out cease and desist letters. You have already spent money to advertise this show. You've already printed up your flyers. You've already done all these things in connection with the show that you want to have. Only for me to step in and say, hey, buddy, you don't have the right to do that. We're going to trademark. So now you have to figure out, oh my gosh, what am I going to do? What you're going to do is you're going to hopefully listen to what I'm saying to you and reprint, your flyers and post on your advertisement and all your social media outlets, be it Facebook, Twitter, YouTube, MySpace, whatever it may be. You want to remove those because you are now opening up yourself to infringement action where I can come in and take your profit. If it is that you now decide, I'm going to ignore her, and when you ignore me, when you ignore people like me, what we say is you are now being, willful infringement. Because you have been informed that I have a trademark. I'm telling you I don't want you to use it, but you say, you know what, bump her, I don't care. I'm just going to go ahead and do my concert, and then I come and I sue you for the damages. And willful infringement, I get treble damages. Not only am I going to get profits, but I can also get punitive damages. Because you have ignored my request to not use the trademark or the copyright or whatever it may be. So those are some of the key things that you have to keep in mind when you are promoting your concert. Make sure that you have the right to use any image, any logo, any phrase. And there are instances where if you're promoting parties, let's say I live in Atlanta, so you have all these people that come. There's really these great names. You have a great name for your party that you have every Friday and every Saturday night, but you don't protect it. So in comes the concert promoter from Detroit. He's like, man, this thing is swinging. He packing it up in here. It's hot. So I'm going to go up to Detroit and I'm going to use that same name that he's used to promote his party down in Atlanta. If you don't have a federal trademark registration for the name of your party, your event, entertainment services, then you will only have for Atlanta, actually, right? The specific region and city where you're using your mark. But if you have a federal trademark registration now, if your parties are successful, and of course as a promoter, you want to be able to do things nationwide or global, right? Based on the success of your show. You can now, when you have a federal registration for your trademark, for the name of your party, you can now take that to Detroit. You can take it to Miami. You can take it to New York. You can take it to LA. And you could then have to say, hey, promoter in Detroit, I know you have a strong following. Let me license the right for you to use this particular, this is a very successful party in Atlanta. Let me allow you to license this and to throw the same type of party in Detroit. And then you do the same thing in LA. And now you have monetized your ability to promote that concert in a state where you don't really have an interest. You're just saying, look, this is a successful show, successful, event that I have every year or, every week. And now you now have money coming in because you're now able to license that time because people are interested. Okay. And you can do the same thing when you go to the Caribbean or you go to Africa or you go to Japan or you go to London where you have great concerts and parties take place there. So you want to make sure that you, even in your business, that you're protecting your intellectual property. Right, that is just so crucial because you have people. For example, there's a promoter here in Atlanta, great party, right? He's well known. He's a big time promoter. He recognizes that someone went and opened an actual location using the name of his parties that he has every week. He doesn't have He doesn't have a trademark. He doesn't have a trademark to prevent that from taking place. Now, because it was in the state, he can say, well, I have some common law rights and things like that. But had he protected his brand, he would have such a stronger case, okay, to say, hey, you got to stop it. And trust me, when you send a letter and you write all the legal stuff in there, people recognize they got to stop, okay? So the thing is that you want to make sure that you are actually in a position to prevent others from using your IP, even in your business. That is just, something that I really want to hit on.